Hello, my name is James Waddington. I'm a member of Foundry Chambers, and like many other barristers in Foundry Chambers, I practice in the field of fraud. Therefore, to some extent at least, it's fraud that you're getting this evening. However, it's more to do with using the law to stop fraud where fraud is suspected, rather than proving fraud beyond reasonable doubt in court. Nevertheless, various new criminal offences have been created to deal with non-compliance with some of this new legislation. So I want to say something about a new Act of Parliament which has been some time in the making, but which has been rushed through Parliament because of Putin's invasion of Ukraine. In the light of a few years where the appetite for enforcement in the field of serious and complex crime has been low, I think it's interesting to examine what message, if any, this Act sends out about the approach that government's taking to serious financial crime. Does this Act herald a more expansive approach to prosecution? Or is it another indication that government is focused on devising more ways other than prosecution to disrupt this type of serious financial crime? My aim this evening is to give you a flavour of the legislation rather than a lot of detail, to talk about its aims and likely effects, so you know where to look if any of this becomes of direct relevance to your work. It's an Act of Parliament in 3 parts. Part 1 is a work in progress and not yet in force, but most of the rest is in force, and Part 1 will come into force during this parliamentary session. Apart from the likely effect on criminal investigations and enforcement as a direct result of these measures, I think this Act does say something about the current and forthcoming approach to tackling serious economic crime. In short, and whether or not there will be more court cases as a result, such offending, so long a topic of discussion rather than action, has been bumped up the political agenda. In summary, on the 15th of March of this year, the Economic Crime Transparency and Enforcement Bill received royal assent, becoming the Economic Crime Transparency and Enforcement Act 2022. The word transparency relates to making the ownership of property, particularly property owned by overseas companies, transparent, where it was not transparent before. The word enforcement relates to various new measures and offences to make it easier to impose financial sanctions and obtain unexplained wealth orders, and to disrupt criminals from hiding their activities behind faceless companies. Part 3 has already been used a lot. That's to do with financial sanctions, which, as we all know, are currently being aimed mainly at Russians. They are now easier to put into place, but also easier to breach by those professional people who might be involved in the business affairs of a newly designated person. Part 2 came into force on the 15th of May. That's to do with unexplained wealth orders. It's a beefing up of a mechanism which has hardly been used, although in force since 2018. The idea is that with a strengthened regime, law enforcement agencies such as the NCA will be more willing to seek these orders. And I think, for what it's worth, that that's likely to happen. Part 1, which is of most interest to me in my work, and perhaps yours too, has not yet come into force, and to some extent is tied up with another economic crime bill due this summer, which concerns setting up a new property register of overseas entities at Companies House. But it's on the way soon enough. and is worth knowing about because it's a big shake-up to do with the registration of companies at Companies House and additional powers which the registrar will have. It's likely to have an effect, in my view, on many financial crime investigations, which may involve, on the one hand, a so-called white-collar crime case, or on the other hand, a case to do with alleged organized crime. To provide context and to shed light on the intentions of Parliament, a brief history of the lead up to the Act may be informative. From at least 2014, London was being described, as you'll all remember, in the press as the money laundering capital of the world. This being mainly in the context of an increase of Russian and Chinese money, allegedly from dubious sources coming into the UK. The complaint was that there was insufficient focus on applying money laundering regulations and no enforcement by agencies such as the FCA. Then in 2015, the Prime Minister David Cameron made a commitment to make property acquisition more transparent. He promised, in the words reported at the time, to go on the offensive against what he called dirty money in the UK property market. And he said that some London property was being bought by people overseas through anonymous shell companies, some with plundered or laundered cash. And these remarks and others made by him at around that time provide the genesis of part one of this Act. Of course, and as is recognized in the Act, buying property through offshore companies is legal, and some who use this route may have legitimate privacy or security reasons for doing so. But behind the cloak of secrecy, the UK property market has long been misused for money laundering or other criminal purposes. This is all well known, yet nothing much has happened in Parliament about this for years. Then, in December of last year, a Home Office and Treasury risk assessment report raised the government's assessment of the money laundering risk for the property market from medium to high. It said that criminals were increasingly laundering illicit funds and that purchases made by corporate structures or trusts based in secrecy jurisdictions pose the greatest level of risk due to the difficulties in determining the ultimate beneficial owners. The document added, corrupt foreign elites continue to be attracted to the UK property market, especially in London, to disguise the proceeds of their corruption. Then, at the end of January of this year, we witnessed the resignation of a UK minister, Lord Agnew, frustrated at the government's refusal to table an economic crime bill, which by that stage had been lurking in the background. Just a month later, wholly due to events in Ukraine, the government had tabled legislation, fast-tracked it through Parliament, and promised further legal reforms in the summer. The government has said that the Act is a vital part of the UK's efforts to tackle Putin and his associates, with the Home Secretary stating that time is up for Putin's cronies hiding dirty money in the UK, and the Prime Minister promising to go faster and harder to tear back the facade that those supporting Putin's campaign to destruction had been hiding behind for so long. However, it has a wide-ranging effect on all sorts of financial crime, as we live in a small world where money travels a long way between multiple jurisdictions and very fast. So, in terms of this act, we could be thinking perhaps under the revamped sanctions regime in Part 3 about preventing the use of Putin's £570 million yacht, as the Italians have just done, having decided he owns it. Or equally, we could be thinking about something a bit more down to earth and closer to home, such as finding out through a new register of foreign-owned properties about the beneficial interests that alleged organized criminals have in a house that they bought from the proceeds of their UK criminal activity. And Part 1 of the Act covers issues which have been talked about for a very long time. For example, I have a case at the moment involving UK property acquisitions by people in the UK through companies in the British Virgin Islands. The activity took place between 2004 and 2008. The allegations being that money was stolen in the UK via various methods, including VAT fraud. The money went from the UK to Dubai and was recycled via BVI companies, which purchased a property portfolio worth the best part of £100 million. The people responsible for this activity were the beneficial, but as far as Companies House is concerned, the secret owners of the property. And the intention is that that sort of scenario is no longer to be allowed at Companies House. So as I said, there are three components to this Act of Parliament. I'm going to say less about Part 3, which is to do with financial sanctions, and the other two parts, as it's less likely, I think, to be of practical interest to most criminal lawyers. I'm going to start with Part 2 of the Act, which concerns amendments that have been made to the Unexplained wealth order regime. It's dealt with in sections 45 to 53 of the Act, and they are in force as from last Sunday, the 15th of May. And as many of you know, by way of background, the Criminal Finances Act 2017 inserted new sections in the Proceeds of Crime Act 2002 to create the Unexplained Wealth Order, which is an investigatory order placed on a respondent whose assets appear disproportionate to their income, to explain the origin of their wealth. And in particular, the respondent must explain their interest in the property and how they acquired it. The procedure doesn't require any proof of an offence having taken place. However, it provides a route to civil recovery under the Proceeds of Crime Act of the assets to which the order relates. The Serious Fraud Office, the FCA, the National Crime Agency, HMRC, and the CPS can seek these orders. And the advantage to a law enforcement agency is that in a very complex case, it can potentially obtain the account of the investigated person and then check it out rather than having to start from scratch with all sorts of jurisdictional and other legal hurdles to overcome in getting hold of the information that they want. The regime is set out in Part 8 of POCA. The procedures in the High Court, applications can be made without notice, and an interim freezing order can be made at the time the order is granted. And the order requires the respondent to explain their interest in property if the combination of the property exceeds £50,000. And, as I've already indicated, the respondent has to say how they obtained this property. In order to jog your memories and to orientate you as to what comes next, the most famous unexplained wealth order so far is that of Zamira Hajiyeva, whose husband, an Azerbaijani banker, was jailed for fraud and embezzlement there. The order concerns suspicions that her £11.5 million Knightsbridge property and £22 million golf course were both illegally funded. Although the order was made in 2018, it wasn't until the end of 2020 that Mrs. Hajiyeva lost her appeals and responded to the questions about the source of the funds used to buy the properties. This case may give the impression that unexplained wealth orders are for powerful foreign money launderers, but there is a more homely example of alleged UK organised crime, of which I think there will be more in the context of using this investigative tool. And this case concerned a man called Mansour Hussain, who was suspected of being linked to gangsters in the north of England. The application for his unexplained wealth order was made in 2019 and focused on the source of money for the purchase of a large number of properties he owned. In his case, there was an agreed settlement in which he handed over 45 properties and retained 4 small properties that are still mortgaged. So what we might take from those 2 contrasting cases is that clearly these orders are mainly for cases of suspected criminality of a serious nature, where there's insufficient evidence to prosecute and a large sum of money up for grabs. However, it might just as easily be a domestic case of suspected crime, as opposed to assets which have come in from another jurisdiction. For our purposes this evening, it's the changes to this regime which are of interest, rather than the detailed resume of what the procedure requires. So in brief, and as to persuading the court to make an order, there are 2 categories of people who can be served with one. Firstly, politically exposed persons, so an individual who is or has been entrusted with prominent public functions by an international organization or by a state. And 2, those of whom there are reasonable grounds for suspecting that they are or have been involved in serious crime, whether in part of the United Kingdom or elsewhere. And it's the second category which is of most interest, the first category presumably being mainly limited, at least, to the type of person who runs off with the GDP of their country and tries to relocate it here. Hitherto, in other words, before the 15th of May, there must also have been reasonable grounds for suspecting that the known sources of the respondent's lawfully obtained income would have been insufficient for the purposes of enabling the respondent to obtain the property. the burden of proof is on a respondent to explain that a particular asset has been obtained through legitimate means. An order is not by itself, of course, a power to recover assets. It requires an answer to questions as an investigative tool for the purpose of civil recovery. A failure to respond to the order means that the property is presumed to be recoverable under POCA civil recovery proceedings. A statement made by a person under the order can't be used against them in criminal proceedings unless they raise it themselves, or they're prosecuted for perjury in relation to it, or for committing a criminal offence under this part of the Act. On the latter point, a person can commit an offence if they provide false or misleading information in response to an unexplained wealth order, and the maximum sentence for that is 2 years imprisonment. Notwithstanding that this is principally about civil recovery, it is, like the rest of POCA, classic territory for criminal lawyers. The agencies with the power to apply for them are criminal agencies. In any event, there may well also be a criminal investigation ongoing into the individual in question. So against that background, what are the changes? I think they are significant. Firstly, where the holder of property is not an individual, so a trust or a company perhaps, the Act's reforms enable an application to specify, depending on the type of entity concerned, an officer, manager, partner, or someone giving instructions to a board of directors or equivalent body to act as the responsible officer for the entity and have the unexplained wealth order served on them. So this makes it easier to obtain unexplained wealth orders where property is held in trust and other complex ownership structures. In other words, a common scenario among wealthy individuals. The second major change is that there is no point embarking on the process of seeking an order like this unless the assets in question are frozen. So the new Act extends the period for which an interim freezing order may take effect from 60 up to a maximum of 186 days, giving the authority more time to investigate. The court may grant extensions to the initial freezing order where it's satisfied that the enforcement authority, 1, needs more time to determine what enforcement or investigatory proceedings should be taken, and 2, is working diligently and expeditiously towards that end, providing that the extension is reasonable in all the circumstances. The third change is that in order to increase or encourage an increase in the number of applications, the Act also prohibits the court from awarding costs against an enforcement authority in unexplained wealth order or related proceedings, such as interim freezing orders and applications in relation to receivers, except where the enforcement authority has acted unreasonably in making or in opposing an application, or acted dishonestly or improperly in the course of the proceedings. Fourthly, a new alternative test for granting an unexplained wealth order is also being introduced. This, I think, is an important change. Prior to the Act, and as I've said, when granting an order, a court had to be satisfied that there are reasonable grounds for suspecting that the known sources of the respondent's lawfully obtained income would have been insufficient for the purposes of enabling the respondent to obtain the property. The Act provides for a further ground, being that there are reasonable grounds for suspecting that the property has been obtained through unlawful conduct. and unlawful conduct is given the meaning in sections 241 to 2 of POCA under the Civil Recovery Powers, and essentially means criminal behaviour. I think this new test will encourage further applications, particularly in conjunction with the costs provision. This test is more straightforward, I think, than entering into a debate about how much money a suspect has and whether what they bought is within their lawful economic range. As with Part 1 of the Act, the government says in its fact sheet that there is a substantial deterrent effect that can be expected from these measures. Although these orders have been available from January 2018, by February of this year, only 9 orders have been issued relating to 4 cases. These have an estimated total value of £143 million. No orders have been obtained since the end of 2019, and the only agency to employ unexplained wealth orders so far has been the National Crime Agency, and there have been failures as well as successes. It's difficult to estimate the likely increase in these orders as a result of the proposed changes. It's still a complex process. Often evidence is required from overseas, and that in itself can present problems depending on the jurisdiction in question. However, I think that taking into account in particular that an agency doesn't have to fear, except in exceptional circumstances, an adverse costs order, and given the addition of the secondary test I've been talking about, it's likely that this procedure will be used more often looking forward. Turning now to Part 3 of this Act, to do with financial sanctions, I think a brief overview of Part 3 is probably sufficient for the purpose of a talk focused on criminal law. Having said that, this area does involve the criminal law, and there's an onerous compliance regime, which means that persons in a business relationship with a sanctioned person may well have to liaise with the body which is in charge of sanctions. So, the implementation and enforcement of financial sanctions is carried out by the Office of Financial Sanctions Implementation. That's part of the Treasury. There's a prohibition on doing business with the people and entities on the sanctions list. That's a very long list, which includes people from many different jurisdictions. And Part 3 is essentially like Part 2, a toughening up of the regime which had been in place before this Act came into being. In relation to sanctions, the idea is to expedite the imposition of sanctions and to deter people from breaching them. As the office explains, and among other stated reasons, sanctions are used to coerce a regime or individuals within a regime into changing their behavior by increasing the cost on them to such an extent that they decide to cease the offending behavior. And usually the office is in the business of freezing assets of designated targets and freezing them out of commercial life in this country by prohibiting access to financial services or any funds. This isn't about seizing or confiscating property, it's about preventing the owner from accessing it. The office also publishes guidance on compliance with the UK sanctions regime. A designated person is likely to have a lot of advisors of one sort or another who look after their money. Insofar as such advisors or custodians are concerned, it can be an offence to receive payment from or make funds available to persons on the sanctions list, or to deal with their economic resources, or engage in actions that directly or indirectly circumvent the financial sanctions. Various persons, such as a regulated financial services provider, an accountant, a lawyer, are required to notify the Treasury if they have dealings with a designated person, or if they suspect that financial sanctions are being breached, and failure to comply with such an obligation may attract a penalty. It's this last issue which is the one I want to highlight, as it's been a serious one for many businesses and lawyers during the last few months, as they seek to ensure compliance and also limit reputational damage. The regulations can quickly change, and the new provisions place a higher burden on them. The onus, of course, is on the business to keep a close eye on and regularly check the regulations for changes. There are both civil and criminal penalties under this regime, and the office can impose a maximum civil penalty of the greater of £1 million or half the value of the breach for breaches of the sanctions rules. Therefore, penalties can or could be enormous. And in fact, there haven't, in practice, been many penalties so far issued. It's far from inconceivable, though, that a bank, for instance, might be slapped with a huge penalty, having been told to stop the money moving elsewhere and having negligently allowed that to happen. Penalty discounts are available for voluntary disclosures depending on the circumstances of the case. And as I've indicated, so far, there have been only a few fines under this regime. In addition to this civil penalty regime, there are criminal offences for which individuals can now be sentenced, depending on the breach, for offences where the maximum ranges from 2 to 7 years imprisonment. Obviously, these offences relate to deliberate attempts to flout the regime. For instance, if a bank or bank official is directed by the office to freeze £10 million and decides instead to send it abroad in accordance with the designated person's instructions, they could face up to 7 years imprisonment. Personally, I'm unaware of any such blatant cases, and the indications are that everyone's terrified of making a blunder on sanctions and of inadvertently getting into trouble. Importantly, the office can license specific activities to be carried out for a designated person, such as a lawyer acting for them in the case. The license is likely to be subject to conditions, and it's an offence not to abide by them or not to take any actions that the license requires. And the office also has powers to request information to establish the extent of funds and economic resources owned, held, or controlled by or on behalf of the designated person, to monitor compliance or detect evasion, or to obtain evidence of the commission of an offence. And it's an offence not to comply with the requirement to provide information or answer a request for information. But the license provision does allow work to be done for a designated person or a designated person, for instance, Mr. Putin, to apply if he accepts ownership of the yacht the Italians have seized, gives them an opportunity to seek a license to keep it in good repair, for instance. Well, what of the changes? What I've said is necessary to make sense of the changes to the regime. And this act amends the Sanctions and Anti-Money Laundering Act of 2018, under which the relevant regulations are made. The changes enable, through a fast-track procedure, the government to impose sanctions on a wider range of persons more quickly, including a streamlined process for making the regulations, and facilitate the alignment of designation of individuals and groups by the UK with designations made by the US, EU, Canada, and Australia. And of course, as we've all seen, this more flexible, streamlined process is proving to be important in relation to Ukraine, so that various different countries and organizations are able to get their sanctions in line with other people. As to the enforcement of breaches of sanctions, under Part 8 of the Policing and Crime Act 2017, civil financial sanctions apply, but they could previously only be imposed on individuals or entities breaching sanctions law where it could be established on a balance of probabilities that the person knew, suspected, or believed themselves to be in breach. Section 146 of that Act is now amended so that there is now no requirement for knowledge or suspicion, effectively allowing the levy of financial penalties on a strict liability basis, regardless of an individual's or entity's intent or mental state. And that's also how it works in the US with their sanctions agency. So, for instance, a breach offence will be committed now regardless of whether a person has a reasonable basis of suspicion that they're dealing with a frozen asset. Section 56 of the new Act gives the office the power to name persons who, on the balance of probability, have breached sanctions, but on whom no financial penalty has been imposed. This naming and shaming power, as it's been referred to, is another powerful tool for the office. There are, of course, now, and in a very short period of time, thousands of sanctions against Russian and Belarusian persons. The office has a far larger pool of designated persons to police, and insofar as, for instance, lawyers or bankers are concerned, it's even more risky looking after persons who are or may be sanctioned, as it's easier to be fined than before, and even if not fined, shamed. Moving on finally to part 1 of the Act, this isn't in force yet, but it's coming soon and has perhaps the widest reach in terms of the criminal investigations that it will interrelate with. It's all about a new overseas entity registration regime at Companies House. The first point is that moving money offshore is not illegal, and there can be legitimate reasons for overseas individuals, including politicians, to do business in the UK via offshore companies. Opposition figures in repressive regimes, for example, sometimes require such forms of anonymity for their holdings. However, shielding the identity of property owners has, as we all know, proved over many years to be useful to foreign and domestic criminals. And according to the explanatory notes to the bill, the Act is intended to deliver transparency about who ultimately owns and controls overseas entities that own land in the UK. So this Act creates a register overseen by Companies House of overseas entities that own UK property, and it relates to land bought after the 1st of January 1999 in England and Wales, and it requires information about the beneficial owners of those entities. It covers companies, partnerships, trusts, and other entities, and it's building, in a sense, on a system that's already in place in relation to UK incorporated companies, which are required to provide information such as I've described for the existing persons with significant control register. Now, the same will apply to overseas entities, introducing a registration requirement which was first announced by David Cameron back in 2016 during that briefing I've already mentioned. Also, there's been a register subject to exceptions for UK and some foreign trusts. In a nutshell, this Act now provides that any overseas entity wishing to own UK land needs to identify their beneficial owners and register. So, what are the requirements? Prior to registering or applying to register, under Section 12 and Schedule 1, the overseas entity must take reasonable steps to identify its registrable beneficial owners and provide information in relation to them. This includes their name, address, date of birth, nationality, job, and role in the entity. Not all beneficial owners need to be registered. As with the persons with significant control regime, Section 2 of the Act defines a beneficial owner as a person who directly or indirectly holds over 25% of the shares or voting rights in the overseas entity, or holds the right to appoint or remove a majority of the board of directors. A beneficial owner is also someone who has the right to exercise or actually exercises significant influence or control over the overseas entity. So officers, managers, or decision makers are clearly covered. For trusts and partnerships, a beneficial owner is the trustee of a trust or the members of the partnership or other entity who meet these conditions. So pretty much any entity that can be thought of is specifically covered by these provisions. In relation to exemptions, because there are limited exemptions to registration, under Section 18, the Secretary of State can, by giving written notice to someone without any parliamentary procedure, exempt them from the registration requirement. And an exempt person is not considered a registrable beneficial owner, so they will not be disclosed on the register and will not have to respond to any information notice submitted to them. But the Secretary of State can only grant an exemption for certain reasons in the interest of national security or for the purpose of preventing or detecting serious crime. So this protects at least some people, probably with a high profile, who might be on the run, for instance, from a hostile regime, who have a legitimate reason for secrecy. Under Section 5, when an overseas entity is registered, Companies House will allocate them an overseas entity ID and send it to them along with details about their date of registration, their duty to keep the register updated, and their right to apply to be removed from the list. The transition period for overseas entities to register beneficial owners is 6 months, so it's going to be interesting to see how many properties are sold in order to avoid registration when this comes out in force. And as the Act goes back to 1999 for registrable entities, there are a lot of entities to be registered. Once registered, the overseas entity must either confirm the information previously provided it's still accurate, or provide updated information to the registrar every 12 months. Various offences have been created. There are fines on a daily default basis for entities or officers who fail to update details on the register when there have been changes, and that's under Section 7 to 8. And there are two main ones which attract custodial sentences. Under Section 34, failure of an entity to register within the 6-month period attracts a sentence of up to 2 years on indictment. Under Section 32, it's an offence for a person without reasonable excuse to make, deliver, or cause to be delivered to the registrar for the purposes of this part any document that's misleading, false, or deceptive in a material particular. An offence is aggravated if, when the document or statement is delivered, the person knows that it's misleading, false, or deceptive in a material particular. The penalty is a fine, or for the aggravated offence, 2 years imprisonment. Also, under Section 35, Sections 1121 to 1123 of the Companies Act are imported into the statute, with the effect that for offences under the Act committed by a company, such as under Section 34, the defaulting officers or equivalent person, as well as the overseas entity itself, may be guilty. What the government says about this? Well, it says this is about introducing a register of overseas entities to crack down on foreign criminals using UK property to launder money. And it says this measure forms part of the government's strategy to combat economic crime, while ensuring legitimate businesses continue to see the UK as a great place to invest. We expect this to have a major dissuasive effect. However, Part 1 of the Act is not in force because it's dependent on wide-ranging changes being put in place at Companies House in order to create the system I've outlined. So the government is committed to introduce another bill early in this parliamentary session, which focuses on changes at Companies House. And at the moment, we have the Corporate Transparency and Register Reform White Paper to go on, published on the 28th of February. It gives an insight into what government thinks will be the benefit of the changes I've been talking about. The changes apply to both domestic and foreign entities. And in a nutshell, the aim is to transform Companies House from a so-called passive recipient of information to a so-called active gatekeeper, playing a more important role in tackling economic crime and promoting corporate transparency. The registrar will be equipped with stronger and more wide-ranging powers to seek evidence about who is actually behind companies. And these include the sort of changes I've been talking about, such as the identity checks. It's a big shake-up at Companies House, particularly bearing in mind that at the moment it's even currently possible to register an appointment at Companies House without the knowledge or consent of the person being registered, because Companies House has no powers to stop that taking place. As I've said, all that is going to change and more. There will also be more extensive legal gateways for data sharing with law enforcement, other government bodies and the private sector. And this will mean more efficient sharing of suspicious activity with law enforcement. It is said again by government that these reforms are a key part of the government's economic crime plan. Also, foreign company formation agents will no longer be able to access Companies House unless the government determines that their jurisdiction has an equivalent supervisory regime. And as the register will apply retrospectively to property bought by overseas owners of up to 20 years ago, there will, of course, be a lot of work being done at Companies House in relation to registration, or those entities will not register and be disposed of in one way or another. So, in conclusion, having given you a brief run through the three parts of this Act of Parliament, all of a sudden, and as a result of events in Ukraine, we have this new act which was brought in to facilitate sanctions, but which also seeks to toughen up the approach to combating international and domestic crime through the new Unexplained Wealth Order framework and a new register of entities at Companies House. Time will tell whether there will be much enforcement as a result of the Part 1 requirements and new offences, as well as the beefed up Unexplained Wealth Order regime under Part 2. However, I think there will be a significant increase in enforcement. Well, that's all I want to say in this very much an overview of this new Act of Parliament, and thank you for tuning in to watch and listen to it.